All right, we're going to go back on the record. The board has met and discussed in executive session concerning the objections that were raised by Objectors Council to Township Exhibit 31, as well as Applicants Exhibit 53, 54, 55, and 56. And after discussion, the board has concluded that the objection to those exhibits will be overruled. Now, those exhibits will be admitted for the limited purpose of rebuttal. The board acknowledges and notes that there is evidence, or there's both rebuttal evidence as well as material that would not be considered rebuttal. The board believes that the issue really goes to the weight rather than the admissibility, and will specifically review the exhibits and will only consider that rebuttal evidence and will not consider any evidence that is essentially new facts that were not raised in the case in chief.
Thank you.
Okay. I think we've resolved all of the evidentiary objections. Am I correct, Mr. Cluck?
I'm just trying to figure out who determines what was a new fact versus rebuttal.
Well, the board is the finder of fact. So the board will make the determination as they will with any other fact that's involved in this case.
Right, but if I want to have serve rebuttal, I'm not going to serve rebuttal to new facts. I'm only going to serve rebuttal to rebuttal. So how do I determine, if you haven't made a determination, what's a new fact? That's why I'm smiling and confused. And that's what I'll do as a lawyer. I'll figure it out.
So you certainly, if you review the exhibits, there are some of the new facts that I can determine are the buffer areas that were proposed by Mr. Cleveland. I think that there is an issue as to what exactly rebuttal is, because in most circumstances rebuttal is an act of persuasion as opposed to changing facts. And so when one of the issues that the board struggles with in this is that while it is appreciated that the applicant is willing to change their plans, that change may or may not really constitute rebuttal, because it's not an act of trying to persuade the board that their position is correct. It's actually changing the facts that for the board to consider. And so that's why I think a lot of this has to go to the weight that's going to be given as opposed to the admissibility. I think it's properly in the record, but I think that the weight that these newer plans are going to be given may be lower than the applicant may desire, because some of the changes, at least in my view, may not be truly what rebuttal is designed for. And I don't know if that gives you any better guidance on how to prepare, but I'm trying to share the thinking of the board with everyone.
Thank you.
I don't think we have anything further this evening.
No, we have one witness remaining, so I assume, I'd like to say it's not going to be very long, but.
Okay. Have you decided, Mr. Cluck, if you're going to have a sir rebuttal case?
Don't know yet.
Okay. So, assuming that there is no sir rebuttal case, we may start public comment at the next hearing. So just anyone who's not a party or represented by counsel will be able make public comment. I remind everyone that the township does have an ordinance, so your comments will be limited to 5 minutes. So one's on due notice on that. At this point, Mr. Chairman, you can entertain. Yes.
June 5 is next. If I do not have a rebuttal case, and if June 5 is as quick as Mr. Gallagher hopes, that is public comment that night.
Yes.
Then we have
We're good.
argument July 11th.
If we complete public comment, then we will start argument July 11 and July 17.
And proposed findings would be due 10 days after.
I think we could address that. I would like to address proposed findings after we get through the hearing, at least.
So I had previously said proposed findings would be 10 days, and that's because we have a 45-day obligation to issue an opinion. Mr. Gallagher has indicated that the applicant may be willing to extend that timeline. In which case, then I would also extend the time for findings of fact and conclusions of law, so that you'll have more than 10 days.
Bless you.
So that's something that the applicant.
I'm not looking forward to 2,000 pages of transcript, but yeah, no, we will have to address that with the client. But yes, I mean,
If we can address that.
But it's after argument?
It's going to be after argument.
Fine.
Yes. Yes. So the next hearing. I'm sorry, Ms. Fowler.
Was there a ruling on the economic impact study?
Thank you. If you can you come forward and remind the board what it was your objection, if I recall.
It hasn't been moved into evidence yet.
So that's why. So it hasn't been moved into evidence. Okay.
You said you were holding off on a vote on it to talk to the board. I think it might have been like 2 hearings ago. You mentioned you were going to bring it up at the next one, and then it kind of.
Yeah, Sean hasn't moved. He produced it in response to my request, but he hasn't moved for its admission.
I can't recall. I believe I did, and it was just.
I think you did.
Looking back at the transcript, you asked for it 3 different times, and we.
Then you produce it. Thank you.
Okay.
All right. So if they're moving it into evidence, I'm objecting to it with no authentication. Somebody needs to testify about it.
I mean, the record states what it states.
Is it your intention to introduce that your next witness would be able to authenticate this?
Mr. Larios testified to this December 5th, and that's the extent of any authentication or testimony that we're going to provide with respect to that exhibit. You asked us to produce it and put it into the record on 3 different occasions during that hearing, and that was in response to what you asked for. So
We asked you to produce it, but
it's part of the record.
I asked you to produce it. In order for it to be made part of the record, it has to be admitted, and it should be authenticated. To do that, it looks like it was prepared by Dr. David G. Loomis. Who is Dr. Loomis?
I don't know. I mean, the transcript from December 5th says, we don't need to produce this. You said produce it. We want it. I said we're not going to present any testimony above it. Mr. Cluck complained that you mentioned it. You need to make this part of the record. So we responded to you, and that's to go back to that, I said, we're not going to present any witnesses. We don't think we need to. It's not even a requirement. However, you asked for this. Here it is.
Don't admit it. If you don't think you need it, don't move for admission.
Right. So are you going to withdraw your request for its admission?
No, I'm not, but you asked for it. It's, you know, my understanding is you wanted to make part of the record. If you want to change, position, go ahead and put it on the record.
The copy I have does not have an exhibit sticker on it, so I don't know if we have marked this or not. Economic impact analysis. A50? Okay. And Mr. Cluck, is your argument is due to lack of authentication?
Yes.
Any other arguments as to why it should not be admitted?
I'd like the opportunity to cross-examine Mr. Loomis or Dr. Loomis about it.
Okay. So I recall that you very vociferously stated that you wanted this to be produced. Why now that it's been produced, do you not want it part of the record?
Oh, it can be part of the record if they have somebody to testify about it.
Okay. The objection to A50 is going to be sustained due to lack of authentication. That if you later produce a witness to authenticate it, we will reconsider that ruling.
We're not going to be presenting any witness, and I know that it gets hard over the course of 20-odd hearings, but the transcript states what the transcript states, and just leave it at that.
Okay. Thank you. The next, anyone else have anything before? Okay. The next hearing is going to be June 5th at 6 o'clock p.m. in this room, the large group instruction room at the Hamburg Area High School. Mr. Chairman, it would be appropriate to entertain a motion to adjourn until that date.
I'd like to make that motion that we adjourn until June 5th. Do I have a second? All in favor say aye. Ayes have it.
Thank you.